No, this was
Oyez, oyez, oyez. Anyone having business before the King's Justice of the Superior Court of Justice, attend now and you shall be heard. Long live the King. The Honorable Justice Hennessy presiding. Please be seated.
Good morning, all. Please go ahead. Good morning, Justice Hennessy. Thank you. Yesterday, I left off in my submissions on behalf of Canada at item 2H of our outline. I'm going to pick up there and address Canada's approach to share, some of which we've already touched on. As to share, Canada stands by its determination that a range of 20% to 50% of share of NCRR for the First Nations is honorable. And as we discussed yesterday, 20% is based on the idea that at the time of the stage 3 trial, the population of the Anishinaabe was about 10% of the entire population of the Robinson Superior Territory. And Canada noted that it's problematic to rely specifically on population shares as the method to determine the appropriate share of NCRR. There are problems with the population approach. One of the problems that my friends had noted at the stage 3 trial was that the 10% population doesn't take into account what the relative populations were over the whole 175-year time period.
So I just want to make sure I've got this, that the 10% population was at the time of the stage 3 trial.
That's right. Yes, it was at the time of the stage 3 trial. And this was addressed in the Mintz and O'Riordan report when they were discussing share. They said one approach is, what is the population share of the Anishinaabe today? Well, it's about 10%. So one alternative would be to say their share should be 10%. Well, the problem with that is, number one, it doesn't reflect their share historically over time, share of the population, that is. And the other problem is it doesn't reflect the fact that they have different needs, that percentage of population isn't correlative necessarily to needs. They may represent at present only 10 or 11% of the population, but that doesn't mean that their needs are only 10 or 11% of the population's needs. So I want to address a question that you had from Mr. Schachter about Canada's reliance on the population-based approach. And here I want to look at the January 27th letter. Again, it's tab 1 of the record. And we're going to look at page 20 of the letter, which is page 32 of the record. So the first full paragraph on that page, the First Nations point out in their January 6, 2025 letter, now this is in response to Canada's December offer, that the percentage of population is not logically correlated to need. They note that small band communities have large and generally inelastic infrastructure needs, which are not correlated to their small populations. Canada acknowledges that a population-based approach is not without its flaws. Nevertheless, the Superior First Nations have chosen to distribute the compensation among their communities based on population. Recognizing there are deficiencies with a population-based approach, it is only one factor which Canada has considered in its determination of compensation. And I wanted to take this to you because you did have a question for Mr. Schachter about this comparison that Canada made between the First Nations using a population-based approach for distributing the compensation. And Canada's not, in this paragraph here, Canada is indicating this is only one factor that's being considered. Canada is not making a judgment about the First Nations choice to distribute on the basis of population. Canada is only noting that even though needs may not correlate with population, it's a reasonable approach in some circumstances. It's the approach the First Nations themselves are taking. So it's not dishonorable for that to have been one of the factors that Canada considered. I'd also like to take you to page.
Theirs isn't a comparison project or they're not comparing population to anything else. They're just making a per cap determination.
Yes, they are. That's right.
Okay.
But as Mr. Schachter noted in the January 6th letter, small band communities still have inelastic infrastructure needs, so their needs are not necessarily correlated with their populations. The main point here being, I just wanted to explain that point because you had asked about it, but what you need to take from this paragraph is that Canada is acknowledging problems with a population-based approach and recognizing it's only one factor Canada considered.
Thank you.
I also want to take you to page 10 of the same letter, which is page 22 of the record. And here I want to look at the final paragraph of that page. Actually, we'll start with the second paragraph under assessing a share for the First Nations, which starts Canada explained. There we are. Canada, are you with me?
I have it, thank you.
Canada explained that the appropriate share would be somewhat dependent on the total present value of NCRR to achieve an overall assessment that was just, fair, and proportionate. Canada proposed that the First Nations share of NCR might be anywhere in a range from 20 to 50%. And here Canada is recounting the position that it took at the stage 3 trial and its December 20th offer. And I just wanted to point that to you. It's a point that I made yesterday that the percentage share is one of the factors that goes into an overall assessment of compensation that is fair, just, and here the word proportionate is used. And that's because in factor 2 that this report directed that the Crowns should consider was the number and needs of the Superior Anishinaabe. And Canada has interpreted the number and needs to mean that Canada should be taking a proportionate response, a proportionate approach to its determination of compensation.
Say that last sentence again, please.
Canada interprets the Supreme Court's direction to consider the number and needs of the Anishinaabe as some kind of direction to consider proportionality.
And is there ever a case in that January 27th letter where Canada justifies their decision as meeting the test of liberality or being liberal? The words used throughout are liberal, just, and honorable.
That's correct. I'll search. I do not recall liberality being specifically expressed, but I do believe that Canada characterizes its determination as generous. But I'll take that back and get back to you once I have a chance to look at the letter again more closely. But I did want to take you to the last paragraph on that page 10, page 22 of the record, to talk about polycentric considerations. And partly I want to draw the court's attention to this because my friend Mr. Gover made submissions that Canada's reliance on polycentric considerations was vague and not linked or explained with reference to any of the particular factors. It was vague and speculative. So here I want to note that the last paragraph on page 10 notes, in view of the Supreme Court's decision, and here we're talking specifically about assessing the share and how polycentric considerations come into the assessment of share. In view of the Supreme Court's decision, that the treaty does not require the Crown to pay the Anishinaabe a specified share of NCRR, but rather that it requires the Crown to exercise its discretion to increase the annuities in order to achieve the treaty purpose of sharing in the wealth of the land. That in exercising its discretion, the Crown should have regard to the relative wealth and needs of all of the Crown subjects. That's at paragraph 181. That the Superior First Nations population in the last 100 years has averaged 6% of the total population of the treaty area. And that Canada provides other means of addressing the needs of the Superior First Nations through discretionary government spending and transfers. Canada does not believe that the honorable exercise of Crown discretion requires the Crown to pay 50% of NCRR since 1850 to the Superior First Nations. Goes on to say Canada acknowledges that it conceded at the Stage 3 trial that Crown liability for augmented annuities could be up to 50% share for the First Nations, based on a total present value of NCRR at that time of 5.5 billion. But as a matter of principle, Canada does not concede that 50% of NCRR is always required to fulfill the treaty promise. So I draw this to your attention to explain the kinds of polycentric considerations that Canada took into account in determining that a range of 20 to 50% is honorable, and that also whether that specific figure picked is the 20% or the 50% is dependent on a number of factors in order to arrive at a holistically appropriate
Can I
figure.
just see that paragraph in full, please?
Oh, I'm sorry. Yes.
Okay. Just,
It's hard to get the 2 pages on the screen, I guess.
okay.
There it is.
So you say this paragraph is an answer to the criticism that the reliance on polycentric communication considerations was vague and speculative.
Yes.
And in this paragraph,
Canada specifies the kind of polycentric considerations that it has in mind here. In view of the fact that in exercising its discretion, the Crown should have regard to the relative wealth and needs of all of the Crown subjects. This consideration about the population averaging 6% really gets at proportionality. And the fact that Canada provides other means of addressing the needs of the Superior First Nations through discretionary government spending and transfers. That's a polycentric consideration.
and you say that is something other than vague? I'm just saying, where's, I see that those are themes, I suppose, but it's a repetition of what the Supreme Court says, should have regard to relative wealth and means. Is that the answer? That's Canada saying we were told to do that, so our decision reflects that. We have had regard to relative wealth and means. And another consideration, we should, or just alerting the nations that Canada provides other means of addressing needs.
This is fleshed out later in the letter when Canada specifically responds to factor 4, what we've called factor 4 of the Supreme Court's decision about the wider needs. So we looked at that yesterday. Factor 4 is discussed on page 29 of Canada's January 27th letter, page 41 of the record. And that's where Canada provides a more detailed explanation of the wider, how it took into consideration the wider needs of Indigenous and non-Indigenous populations. And that's where I had taken you to the paragraph yesterday that mentioned that Canada has determined its compensation to the Superior First Nations in light of the undisputed fact that there are hundreds of other impoverished First Nations communities across the country that rely on discretionary funding from Canada to assist in meeting their needs. Now, paragraph 4, or sorry, that discussion of factor 4 goes on to provide some further explanation by mentioning Canada's 2024 fall economic statement. And noted at the end of that paragraph on the fall economic statement that the economic statement demonstrates, the figures in that statement are noted there. They demonstrate the extent of the needs of other Indigenous Canadians, which include over 600 other First Nations nationally, as well as Inuit and Métis. And Canada goes on to say that the fall economic statement, taken together with significant risks to the Canadian economy posed by the threat by the United States to impose a 25% tariff on Canadian goods, demonstrates the important economic conditions that Canada must consider in its polycentric decision-making. Canada hasn't been more detailed than that, Justice Hennessy. And some of these polycentric considerations, of course, are they're policy decisions to be made by the executive, quite often in cabinet. I just wanted to note as well, recognizing that these polycentric considerations came into play did not result in a deduction in compensation to be paid. It rather explains why Canada determined that it was honorable to use a 20 to 50% value for the share for the First Nations. It's not like there was a deduction applied. Now, I want to compare this approach to share with the approach that the plaintiffs' experts Stiglitz and Hutchings took, and why Canada decided not to take their approach. So you will remember, I'm sure, that Stiglitz and Hutchings, their approach was that the Anishinaabe share should be at least 84% and possibly more than 100%. So when they talked about the 84%, they described this based on this theory that in prior treaties.
I don't actually need to hear you much on the 80.
You don't need to hear me. Thank you. So I did have the excerpts in the compendium about that. And the point I wanted to make, Justice Hennessy, is Stiglitz and Hutchings were wrong. They were wrong because their impression, they were under the false impression, they admitted, it's apparent on the cross-examination transcripts that we've included in the compendium. They misunderstood those $10 treaties. They indicated in their reports that the $10 was fixed, when in fact we know from your own finding in stage 1 that no, the $10 was based, it was $10 per person alive at the time of the treaty. As the population of those First Nations increased, the per capita amount decreased from $10. So Stiglitz and Hutchings were wrong in relying on $10 because that wasn't a fixed amount. It was entirely dependent on the population and it decreased as the population grew. And furthermore, Stiglitz and Hutchings contradicted one another as to whether or not $10 should be considered the buy outright price for the land. So my point here is simply that Stiglitz and Hutchings were wrong on this point. And this is an example about why Canada has approached their evidence with scrutiny and taken some parts of their evidence and not other parts. I'll come back to what I said earlier. It's not science. It's not gospel. And in the words of an eminent jurist, you don't get to say, I've got a guy who's got a Nobel Prize, I win. It was reasonable for Canada to choose to prefer the analysis of Mintz and O'Riordan over Stiglitz.
Well, neither of those statements, in my view, permit Canada to rely on one part of the evidence or not. It seems to me Canada's job, as is everyone's job, is to look at every bit of the evidence.
That's correct, and Canada has done so. Canada has adopted Stiglitz and Hutchings' approach to NCRR in preference to Smart and Boldway, when they determined to use a figure that was closer to Hutchings, and in fact, Hutchings' full NCR figure. So Canada has taken some of the evidence from Stiglitz and Hutchings.
Well, it's just that you say they were wrong on 84%, their theory behind 84%. Therefore, we discount their other evidence. I would say then you would be in the same boat if you relied on any evidence from Smart and Bigger, because they were wrong on some things, as were all the experts. So I don't in my job think that if you're wrong on one point, the rest of your evidence should be discounted.
And we are at IDM on that point, Justice
Okay.
Hennessy. Absolutely. And in fact, I wanted to take you to Smart and Boldway, because Smart and Boldway were heavily criticized. In fact, I would say the harshest criticism that Stiglitz and Hutchings made of Smart and Boldway was probably their risk-adjusted approach. This idea that Smart and Boldway were trying to get away from a fixed percentage share. And so they came up with this theory in keeping with the concern about, fixing on a percentage share, which the Court of Appeal expressed concern about that. The First Nations themselves have expressed concern. So Smart and Boldway tried to come up with an idea that wouldn't be tied to a specific percentage. And instead, they based their idea on, instead of a fixed share, the share for the Anishinaabe should be high in the years following the treaty, but lower 50 to 100 years later, because those future years of revenues would be unpredictable and therefore very risky. So the share for the First Nations should be lower given the higher risk. They would rather have the high share at the beginning when they had more certainty about what revenues might be, was the theory. And I noted, and I've included in the compendium, and I'm saying this is a theory that Canada did not adopt. It was criticized and did not factor into Canada's consideration of honorable compensation. But it struck me that the chart that Mr. Schachter referred you to in his compendium, it's actually the next chart, Ms. McNamara, at tab 16 of our compendium. This chart, Mr. Schachter referred you to, that shows, and this is from Stiglitz and Hutchings, actually Hutchings' report. It shows that over time, Ontario's share of revenues from resources has declined. And it struck me that it bears a resemblance to Smart and Boldway's chart, which is at tab 15.
Ontario's share or Ontario's revenues?
Ontario's revenues.
Thank you.
Ontario's revenues from resources have decreased. In fact, I think Mr. Schachter used the point to now at 0.2%, I think is what Mr. Schachter told us, about 0.2% of Ontario's total revenues now. And he took us to the graph to show that it's really just a sliver of Ontario's revenues these days, resource revenues. And that actually, I would suggest, mirrors this chart from Smart and Boldway, where they say if they use their risk-adjusted approach, the share for the Anishinaabe would decrease. And I only bring this to your attention, Justice Hennessy, not because Canada relies on Smart and Boldway's assessment of this risk-adjusted share approach, but just for the point that Smart and Boldway may have been onto something when they considered risk. And the Smart and Boldway approach, although not one the court adopted or Canada adopted, it would be wrong to conclude that Smart and Boldway have nothing useful for Canada or the court to consider. Canada considered Smart and Boldway's rejection of the economic rents approach, considered their NCR numbers in comparison with Hutchings numbers, although took them with a fair bit of scrutiny, and also considered their comments on the appropriate bring forward rate. So to your point, just because an expert made a mistake or was less credible on one aspect of their testimony doesn't mean you throw the baby out with the bathwater. It's an exercise of using good judgment about what parts ring true, make sense, and are compelling, and which other parts aren't. I'm now on to item 2I of my outline, which is related issues. And I think we can go through them fairly quickly because I think we've already touched on them. The first is the Canada's estimate for revenues for the period from 2020 to 2025. And I think, Justice Hennessy, I've already gone through that. You can let me know if you'd like me to do that again, but it's explained in Canada's December 20th letter at page 3019 of the record. We went through this yesterday.
I don't have any questions related.
Okay, good.
Thank you.
I just wanted to respond to my friend's concern that Canada's inclusion of 120 million in respect of the last 5 years was arbitrary, and remind the court that there was a methodology to Canada's determination. But the next issue I want to address is annuities already paid. And this, I think, as well, I can deal with briefly, because I now understand my friends to be acknowledging that the annuities already paid are appropriately valued at about $300 million. That's the same figure that Hutchings came up with. It's the figure Smart and Bodway used repeatedly throughout their materials during testimony. And it's also the same figure that Booth and Kersner came to in their report. I think we're all agreed.
Just at bond rate.
Yes, that's the bond rate. It would be a much higher amount, of course, if it were at the 60/40 rate, or even the BTA rate. It would be much higher than 302 million. But we're content to use the bond rate, the lowest amount, 302 million, to value the annuities already paid. My understanding is that my friend's concern with Canada considering the annuities already paid is that they were paid to the wrong party. They were paid to individuals rather than to the collective. And the Supreme Court has told us that the annuity is not owed to individuals. It's owed to the collective. Canada addresses this in its factum. In short, literally up until the Supreme Court's decision in July of 2024, the First Nations argued that there was an individual entitlement to annuities, at least an individual distributive amount. You remember that the plaintiff's theory was there was a distributive amount to the annuity that was owed to individuals. The language of the treaty promise itself refers to payments to individuals. All of this to say, not that the Supreme Court is wrong in determining it's actually a collective amount, but that it was not dishonorable for Canada to have paid the equivalent of $302 million to individuals.
That maybe there are two questions then. Was it dishonorable to pay it that way? Or is it honorable to take it into account now when it wasn't paid to the banks?
In my submission, it is honorable to take it into account now because it was honorable to pay it to the individuals. And the second point that Canada makes in its...
Well, can I just take you back to that then? As I said, so those may be two separate questions. So let's go with the first, paying to the individuals. You say it's honorable because 150 years later, counsel says that's what was owed. When we know that the Supreme Court of Canada has said it was never owed to the individuals. Well,
During the negotiation and engagement sessions, this issue came up and Canada asked, is it the case that the First Nations, all of the First Nations agree that the annuity is owed to the collective and not to individuals? And this was a point on which the First Nations requested a caucus. And after their caucus, returned to say they acknowledged the Supreme Court said it was collective. It is a contentious issue, Justice Hennessy.
Where?
Among the First Nations.
At the band level?
That's my understanding. And the reason I say that is that the First Nations, up until the Supreme Court's decision, did take the position that at least some portion of the annuity was owed to individuals.
Mm-hmm.
I don't want to press that point too far, but I just want to acknowledge why, in my submission, it can't be considered dishonorable for Canada to have paid annuities to individuals. Keeping in mind as well, the language
Not
of the treaty.
payment. That's why I'm saying there's two different questions. It's whether what's under review now is whether it should be taken into account.
Yes, that was your second question. I was addressing the first part.
Oh, whether it's dishonorable,
Yes.
was dishonorable to pay them. Okay.
And they are kind of related because when I address your second part, is it dishonorable now to deduct the $300 million already paid? Part of my answer is it's not dishonorable to deduct it because we have to have in mind that it was honorably done at the time is the first part. The second part that is noted in Canada's materials is that payments to individuals would nevertheless have had some positive impact on the community as a whole. That's a point that's
Well, that's if you say that $2 going into the economy by individuals is the same as $200 going to the collective.
I'm not saying it's the same. I'm saying it would have had some effect. It's not like it wouldn't have had any effect at all.
Okay.
In our fact, and we also explain the math, that if you are not going to deduct the $302 million already paid, then in fact, you will be double counting it because you will add it back in, but it's already been paid and it really increases then the amount that will be paid to the First Nations to over $4 billion. That is explained in our factum.
But at the end of the day, notwithstanding that it may be contentious at the band level, you don't dispute the impact of what the Supreme Court says.
We don't dispute that the Supreme Court has told us it's a collective entitlement.
Okay. And that it always was.
And that it always was. That's what the Supreme Court has told us in their interpretation of the treaty, and Canada obviously accepts that. It's a little bit of a red herring, though, I'd say, Justice Hennessy, because $300 million, it doesn't actually make that great a difference to Canada's assessment. I also wanted to touch on, just respond briefly to my friend's claim for what Canada views as the White Sand and Red Rock's claim for additional compensation for anguish and anxiety caused by the litigation. Canada addresses this in its factum, and I note that Ontario addressed it as well. And Canada views this as really a claim for litigation stress. Canada cites case law in support of the proposition that the stress of litigation itself is not compensable. Mr. Schachter referred the court to malicious prosecution cases as an analogy where compensation has been provided for mental suffering. But those cases are different because what is being compensated for is a direct harm caused by not the litigation process, but by the conduct of the Crown in a malicious prosecution case. And Canada has already compensated for emotional and psychological losses as part of its overall determination that $3.6 billion is honorable compensation. Furthermore, Canada notes that White Sand and Red Rock are being generously compensated for expenses relating to the process of litigation beyond the typical kinds of costs and expenses you would see in, for example, an award of costs under Rule 57. White Sand and Red Rock are being compensated for payments such as honoraria to their chiefs and council, and for firekeepers and community meetings. And for that, I'd like to take you to the record at tabs 58 and 59. Actually, 58 is the refers to the expenses of the Fort William First Nation. But the one that I really want to refer to in response to this question, this issue, is White Sand and Red Rock's expenses, which are at tab 59. And Schedule A to tab 59 indicates on 2 pages the kinds of expenses that the White Sand and Red Rock First Nations have been reimbursed for. And they include about $150,000 in honoraria for chief and council and elders, and about $30,000 for firekeeper, and about $36,000 for community meetings, all of which Canada has agreed to reimburse the First Nations for. But the point here is that in some respects, Canada has responded to expenses of the First Nation that go beyond the typical kinds of expenses that one would expect in litigation. Now, I want to note, and I'm not sure now is the right time, but Canada's share of the 3.6 billion that is owed to the 6 First Nations who are treaty beneficiaries has been fully paid. My understanding is not all of the $20 million in costs that Canada owes has yet been paid to the First Nations. But I've been advised, and my friends have been advised, that that payment is expected by the last week of June, and July 4th at the latest is the information. So when I say Canada has paid these amounts, what I'm saying is Canada has committed to pay them, has promised to pay them, but I do not believe that, I know for sure that Mr. Schachter's firm has not been yet reimbursed his share, which is $17 million of costs.
Can we go to, so the 6 First Nations who are treaty beneficiaries have received their money. The 6 who have contingent interests those payments are in the works, but the commitment has been made as part of the 3.6.
It's been agreed upon what their share is, but they won't be paid until their Aboriginal title claims are resolved.
Right, they've been set aside.
That's right.
And then the 20 million commitment has or has not been paid?
Has not been paid. It's been committed, but it has not all been paid out. It's a paperwork issue. Canada's not at all resiling from its promise to pay the 20 million in costs. And of course, remember that's on top of over 5 million that Canada paid throughout the process itself to fund the First Nations in the negotiation process.
In the engagement process?
That's right.
Okay.
Yeah. And that's also described in Canada's January 27th letter, of course. So Canada did pay over $5 million during the negotiation and engagement process to assist with the First Nations costs of that process, and then also committed to pay $20 million in costs as part of its exercise of discretion. And it's that 20 million that is still in the works.
And is there any complication to it?
I don't think no, there's no complication, and it's not, I only mention it to you, Justice Hennessy, because during some of our case management conferences, there was questions of what is the status of the payment? What is the status of the payment? And I just wanted to let you know, and particularly because I had in my submissions just said that White Sand and Red Rock have been paid for chiefs and council and honorary and firekeepers. In fact, the verb tense should have been are being paid or will be paid by the end of the month.
Okay, thank you. Thank you.
The last issue that I wanted to address, again, I can do it very briefly on this exercise of discretion, is a response to my friend's reliance on the Ward versus BC case in support of the claim by the First Nations for additional compensation to represent vindication and deterrence. And similar to those malicious prosecution cases, my answer to that is, in the Ward case, charter damages were awarded to address vindication and deterrence because no other damages or compensation was ordered. Here we have $3.6 billion being awarded, and Canada's position is that award in itself serves the purposes of vindication and deterrence. Ward is clear that if the tort claim meets the objectives of charter damages, recourse to charter damages will be unnecessary. In other words, it's not that damages for vindication and deterrence are to be added on top of compensation. But rather, if no other compensation is available, as was the case in Ward, that's a ground on which damages can be awarded under the charter. But in a situation like we have here, where there is already a route to compensation of $3.6 billion, that $3.6 billion serves the purposes of vindication and deterrence.
You say that the mere fact, even if it had been $500,000, or is that what you're saying?
Yes.
Is it
Yes,
okay.
the compensation.
Mere fact that there is compensation is meets the goals of vindication and deterrence.
That's correct.
Whereas in Ward there was none,
That's correct.
and that vindication and deterrence are not separate heads of damages when there is a tort award.
That's correct. I'd like to move on then to the RHT settlement as a benchmark. I'll reiterate that Canada determined compensation for the RST independently of the RHT settlement. We've been through that. This is demonstrated by the fact that Canada explained its methodology in its opening statement at the stage 3 trial, even before the stage 3 trial.
I'm not sure I asked this question yesterday. The opening of the stage 3 trial was after your resolution agreement with the Hurons.
It was pretty well concurrent.
But the amount would have been fixed by Canada, or the parties would have come to that amount, $10 billion by then.
By the time that Canada delivered its opening statement,
Yes.
I cannot recall precisely, but it's likely that, because I do recall January 30th is a date that sticks in my mind. That was, I think, I do think it was the case that the Robinson Hurons indicated that they would be pulling out of the trial before the trial actually began.
Yes.
Yes.
But
So-
that's my recollection of the chronology.
Yes. So the chronology then, I think, would be fair to say that, I don't know if I'm telling tales out of school, because I don't know whether it is the Hurons did note that they were intending to settle. Whether or not a settlement had actually been achieved at that point, I'll ask my friend to speak to that.
Okay, but I don't actually need to know that specifically, and you may ask Hurons to speak to it. But for the court purposes, what was on the record is the Hurons had left the trial and advised the court that they had reached a resolution.
And I think we can leave it at that.
Is that all right? And then the trial started and Canada opened. So I would come to the conclusion that Canada either had a deal for $10 billion or were very, very close to a deal for that much. I only raise that because you say the amount of compensation that Canada was offering, Canada put out in their opening statement or close.
Yes, yes. And
And my question is, and you say that demonstrates that Canada did that independently of the Huron settlement. And my question is, well, how independently? You've got, well, I don't know, the week before you make a deal for 10 billion, you know what the population is, and then you appear in court and you make an offer to the superiors for what appears to be, and what you now explain to be about 25% of that, which happens to represent, or I'll just say 25% of that.
yes,
That-
and
Would that chronology be right?
I think so. And in fact, Mr. Grover made that suggestion during his submissions that the timing was tight, and it may not be fair for Canada to ask the court to draw an inference that Canada came up with 2.5 billion for the RST before it agreed to 10 billion for the RHT. And I acknowledge that evidence isn't actually before you. You know, there may be inferences you can draw about the timing, but Mr. Grover noted the timing was very, very tight. And you yourself have noted that the Huron settlement, some resolution was reached before the Superior trial. Then again, you don't know the timing of the $2.5 billion offer. It was before the trial as well, and you don't know the precise timing of that. So I realize that we're getting down a bit of a rabbit hole that may be problematic. And I think all of this was in support of my submission that Canada developed its determination of compensation for the RST independently of the RHT. And I was using that as an example to try to provide some evidence that would help the court come to that conclusion. But in the absence of that kind of evidence, then, and in fact, it isn't really evidence, it's inferences that can be drawn. In the absence of any inferences that can be drawn, the other proof that you have, Justice Hennessy, that Canada developed its position on RST compensation independently of the RHT is the methodology that Canada followed, regardless of what the RHT settlement was. The methodology that Canada followed was consistent throughout and always came to a figure of about $2.5 billion. And this does, I just want to put in an extra emphasis that,
And sorry, if you don't mind just telling me what you say are the elements of the methodology. They are look at benefits.
Look at
NCR.
NCRR, not economic rents, more heavily weighted to Hutchings. And we didn't say in the opening statement more heavily weighted to Hutchings, but we certainly said it in the closing statement. Take the bring forward at a rate other than 60/40, some kind of a blend of the Booth-Kersner approach or the BTA or the bond rate, something other than 60/40, and a share of up to 50%.
And does Canada ever name the rate that they use?
No, because Canada uses not one particular figure. It assesses different scenarios, some of which can only be compared on the bond rate, because that's the only evidence that was before the court. Remember? So when, on the other hand, when Canada looks at scenario 3, it looks at the BTA rate, because that's the rate that Mr. Hutchings used in his estimate of full NCRR. So Canada doesn't settle on one rate in particular. Canada says it's one of these rates. They're all in this range of Booth-Kersner, BTA bond. They're all in the range of roughly 5%. BTA is 5.3. Of course, these minor changes in the rate have very large implications. But again, Canada's not doing a precise mathematical calculation. We're looking at a range. And I just want to put in an emphasis again on the fact that Canada has no idea, and maybe I shouldn't even phrase it that way. Canada can certainly not speak to what was behind the thinking of the Huron plaintiffs when they settled for 10 billion, or even what was behind the thinking of Ontario when they settled for 10 billion. And I just want to make that absolutely clear. Canada is not suggesting that the RHT agreed with Canada's methodology. So, but Canada does submit that it was reasonable and appropriate for Canada to consider the RHT settlement as a benchmark, after having determined that honorable compensation for the RST First Nations would be in the range of about $2.5 billion. And we see that in the December 20th letter, where we look through scenarios 1, 2, and 3, and we're in a range of between 1.9 and 2.51. Canada had determined about 2.5 billion is a range that is honorable. Well, how would that compare with other precedents? as I noted, one precedent, one comparison was the $10 benchmark, which Canada has abandoned. But Canada did think, well, what other precedents are there? There are no other precedents other than the RHT settlement. And the RHT settlement has the benefit of actually being in respect of the exact same treaty language.
But my question was, when I read that, why would you think precedents would be something to look for? It's a sui generis treaty.
So, I'm sorry?
Well, you say there are no other precedents, but my question was, when I heard that, but why would you think there would be precedents?
Well, there is another precedent, though, the RHT settlement.
No, but why would you think, when you say there are no other precedents, why would you go looking for precedents? We know it's a one-off treaty. So if you say, well, I guess we should look at what we did with the RHT.
Well, it's reasonable, I submit, Justice Hennessy, for any determination of compensation, especially when it's one that's based on polycentric considerations and a holistic view of things. You've got to benchmark it against something.
Well,
And
I don't, it seems like a predetermined question. You say you're looking for, you suggest you're looking for precedents. But I say, why would you look for precedents? Perhaps what you're looking for, or perhaps what you're doing is saying, we did this once. We should do it again, and we should create a precedent. We should create a pattern.
And I submit, Justice Hennessy, that is one way of looking at it, but it's a cynical way of looking at it. And it's not the way that Canada looked at it. Canada has explained it came up with its determination of compensation for the superiors and then felt the need to validate its process and consider benchmarks. And so it may be a stretch or it's been misinterpreted when I've used the idea of looking for precedents. Canada was looking for a way to validate its determination. And we saw that, I mean, that comes back to, I think, about the Booth-Kersner approach. They went through their approach and they said, let's validate that by what if everything had been invested this way? What if everything had been invested that way? It's a common process for parties developing an economic response or a measure of damages to consider a validation exercise. And the court may determine that the RHT was not an appropriate validation exercise, and that's perfectly fine.
Well, I don't have a view of that yet, but I do worry that when you say you were looking for precedents or that you thought it was a precedent, I think of those lawyers who practice in the area of personal injury, and they say we have to compensate someone for a broken ankle. So we look at 100 cases of broken ankles and we say, well, there's a way to benchmark what we've done. But if you were involved in the only other broken ankle case in the universe, and that's what you paid last year, is that a validation, or is that just, that's what we do?
And
No, I'm just saying, I'm having trouble with this notion that it was a precedent that validated.
And I understand your perspective, Justice Hennessy. I understand what you're saying. I'm nevertheless going to go through 3 points about why I do think that the RHT is an appropriate benchmark. I think the concern here is understanding what is meant by the term benchmark. And I don't think I'm being clear in or successful in convincing you that I need to make the point.
I don't challenge the benchmark status that you give to the RHT settlement. It was this notion of
precedent.
So I don't want you to think that I'm predetermined on this benchmarking.
Thank
Go
you.
ahead.
Thank you. And actually, thank you for articulating that difference, because that is what I was hoping to get at. I understand your concern about the language of precedent, using it as a precedent. And you've given a good example about, the broken ankle charts of what other cases have done. That is not how Canada used the RHT settlement. It was used as a benchmark. And I think chronologically, the point that I'm trying to make is if it was used as a precedent, Canada would have taken the RHT settlement and then just fit the RST into it. And what Canada is telling you in its materials is that's not the chronology. The chronology is Canada determined the RHT, appropriate amount for the RHT, then benchmarked it against the RHT settlement. Did I say I missed up the RSs and the RHs. Do I need to say that again, Justice Hennessy, or have you followed me?
You determined the RST
Yes.
amount, the appropriateness of it, and then benchmarked it against the RHT.
HT, that's correct. And I thank you, my friends and colleague, for catching me on that error. The point being, again, I'm trying to make the point that chronologically, it's not as though Canada used the prior settlement to decide what to pay the superiors. Canada decided what to pay the superiors, then validated that determination against the benchmark of the Huron settlement. Now, how can I prove that?
Is it another way to say I'm feeding you lines here? Is it another way to say you didn't feel bound by?
That's correct.
That's what you're saying.
Yes. And just to sum up, I've told you now that Canada determined the compensation for the superiors, then benchmarked that against what was paid to the Hurons. And how can I prove that that was chronologically what happened? Well, this is the rabbit hole we went down. I don't think I actually can prove that. I can ask you to draw inferences. It's not clear. And so I'm not going to say that you do need to draw any inferences. I think what you're going to have to do is accept Canada's word on this. And I do think it aligns with the fact that Canada's methodology has been consistent throughout. If Canada had simply taken their settlement with the Hurons and said, okay, what's a proportionate share for the superiors? That doesn't fit with the fact that Canada has already explicitly explained how it came up with the $2.5 billion that it did, with reference to the evidence in the superior case. In any event, I'd like to go through the RHT settlement, and I have basically 3 points to make on that. Effectively, using the Huron settlement as a benchmark had the effect of increasing Canada's payment to the superiors in this respect. Canada had determined, using its scenario-based approach, that $2.5 billion would be honorable. Canada knew that it had to, or it determined that it should augment that in order to account for the nature and severity of the breach and the additional needs of the superior First Nations. But Canada did have in mind this general notion that in order to be honorable, the payment made to the superior First Nations should not be significantly different on a per capita basis than what the Hurons received.
Let me see if I've got that. Taking into account the nature and severity of the breach and the additional needs of the superior First Nations, Canada did have in mind that the superior amount should not be significantly different on a per capita basis.
Yes, and
is this another way of saying you focused on nature's severity and additional needs more than NCRRs? Yeah, I'm not sure I'm not sure how you what you're saying when you took into account nature and severity, and that moved Canada to, I believe you're saying, increase the determination or increase the amount that you determined was honorable.
That's right. Those considerations did increase the amount. And Canada explains that in its January 27th letter, that it doesn't just land at 2.5 billion and leave it there. Canada goes on to consider, is this amount liberal, just, honorable? Does it address what we've heard from the First Nations about their very significant needs and their concerns about the nature and severity of the breach? Does it address these things? And Canada determines that another factor Canada determines is, well, it would be honorable that the figure should not be significantly different, like significantly lower than what the Hurons received. Now, the Hurons, as we've heard, the productivity of their land was 4 times that of the Superiors. But Canada determined that, although that's a consideration, and the treaty tells us that productivity of the land is the economic circumstance to be considered, Canada determined that an honorable approach to compensation would be to also take into account that there shouldn't be a significant difference on a per capita basis between the Hurons and the Superiors, despite the fact that the Superiors had much less productivity.
Lower.
Yes, lower productivity. And I'd like to take you to where that is addressed specifically in Canada's letter, which is at page 47 of the record, which is page 35 of the January 27th letter. And again, Justice Hennessy, I'll remind you that the January 27th letter really follows closely to the December 20th letter of offer. And I note this because Canada's intention was it would, as is often the case in administrative decision-making in judicial reviews, the decision maker tells the affected party, this is what we're thinking, this is what we're considering, and this is what you're thinking. What's your response? And then takes into consideration the response to develop its final position. And that's why you'll see a lot of repetitiveness between the December 20 letter and the January 27th letter. And I want to point that out because I don't want you to feel that or get the mistaken impression that these ideas were sprung on the First Nations at the last minute. This was something that was discussed with the First Nations, at least after December the 20th, because it was included in the December 20th letter. But so let's look at the particular paragraph where Canada discusses methodologies for comparing the RHT settlement and notes that in the first paragraph, partway down, the First Nations argue that, quote, parity with the RHT on a per capita basis is irrelevant for identifying the proper augmentations that should be made. This was their letter of November 21. They said that parity on a per capita basis was irrelevant. This is because they were looking for substantially more per capita.
Sorry, what's the?
We're looking at.
Oh, you're responding to the First Nations letter.
That's correct. In Canada's January 27th letter, the parts in brackets or parentheses are letters from the First Nations that Canada's responding to, and they're listed in an appendix. Yeah. So
thank you.
That November 21st letter you will find in the record in chronological order.
Yes. Thank you.
The First Nations also note that the populations of the two groups of First Nations differed as compared with one another over time, which they see as one of the many reasons for which achieving parity on a per capita basis should be irrelevant. So Canada acknowledges that the Superior First Nations are not interested in parity with the Hurons, and that's because in their view, the compensation should be much, much higher. Canada goes on to say, Canada agrees that achieving parity with the Huron settlement on a per capita basis should not be the goal when the Crown exercises its discretion to determine the amount of annuity augmentations. Rather, since the purpose of the treaty promise is to, quote, share in the wealth of the land, close quote, the more relevant consideration is the productivity of the particular lands. Then Canada explains on the next page, starting furthermore, Although Canada does not consider achieving parity with the Hurons on a per capita basis as a goal of its determination of compensation, Canada considers that the total amount it has assessed to pay to the Superior First Nations should be reasonably comparable on a per capita basis to account for their needs, despite the fact that the productivity of the Robinson Superior lands was lower. So Canada is noting, and we went through this passage yesterday, perhaps Canada could have fleshed it out, being a bit more articulate here. But Canada is definitely noting that one of its considerations is that there be reasonable comparability between, on a per capita basis, between what the Superior First Nations receive and what the Huron First Nations receive, even despite the fact that the productivity of the land is different.
And when you say reasonable comparability, you're very much talking about the per capita.
Yes, on a per capita basis. And so you'll see that in the end, in that same paragraph, Canada goes on to say, and you'll see different figures about this, the population of the Superiors was roughly at that point 37% of the Huron First Nations population. I think other calculations in the record may say 36 or 38%. And of course, the total amount of compensation that Canada determined is 3.6 billion. And Mr. Gover made this point in December, the offer that Canada made in December, which Canada believes was honorable, it's within that range of honorable results of 3 billion, wasn't directly linked to this percentage of population. So that's where I'm saying that the amount should be reasonably comparable on a population basis. It's not that Canada was striving to have a precise amount to equalize the per capita amount. And I mention that because my friends have suggested that you can draw an inference that the Crown's decided ahead of time, what we're just going to give a proportionate share based on population. It's per capita. I think my friends have said it's, remarkable coincidence that 3.6 billion is roughly the percentage, or almost exactly the 37 or 36%. And my answer to that is Canada had the same view and the same approach when it offered 3 billion. So it's not, and I just suggest that as
the same approach, the same methodology.
The same methodology of, well, let's increase the compensation beyond what you would get as a share of NCRR. Let's increase it because we've got other goals to consider. One is we want to address nature and severity. We want to address special needs, as compared with the RHT, for example. We want to have a figure that is reasonably comparable on a per capita basis. So those are reasons to increase the compensation to be paid to the superiors. The next, I advised that I had 3 points I wanted to make on the RHT settlement. And the next point is, maybe we'll be brief, it's that the RHT settlement is an honorable settlement. I heard Mr. Gover make that concession on behalf of the contingent interest First Nations. I'm not sure that the White Sand Red Rock group of First Nations agree that the Huron settlement was honorable. But Canada's position on this is the Supreme Court has said many times, has spoken many times about the preference for negotiated settlements over litigation. Settlements are always to be preferred. Justice Hennessy, you mentioned one of the reasons would be certainty. Settlements provide certainty for the parties. But other benefits of settlements are that they allow parties to continue their relationship in a less adversarial way. And this is especially important here where we have a perpetual relationship under the treaty. And the other reason that's...
I'm so glad you didn't say a perpetual adversarial relationship. Go ahead.
And also because, frankly, the parties are best equipped to reach a resolution because there are so many facts and considerations and that come into play. It's really putting a lot of strain on the court to be able to deal with this vast array of facts and history and positions and step in from the outside in a relatively short period of time and come up with a resolution. It's asking a lot of the court, and the parties themselves are the ones that really know the facts inside out and are therefore better equipped to reach a resolution. Here, of course, the Hurons had very competent counsel and a very well-developed decision-making structure. Canada must be permitted to assume that the Hurons negotiated the settlement they wanted and were pleased with the result. Because if Canada cannot assume that the Hurons were pleased with the result and that they viewed it as honorable, then there would be no incentive for Canada to settle at all. If Canada cannot trust that the First Nations can come to a negotiated resolution and that the court is always needed to step in as what Mr. Schachter called the neutral arbiter of what is honorable, then there would be never any incentive for Canada to settle, because it wouldn't be able to trust that the First Nations it wouldn't be able to trust the First Nations in coming to any agreement. It would always have to turn to the courts. If Canada can't trust that the First Nations are well represented, I mean, if Canada has indications to believe that their counsel is, acting incompetently, it would be different. But here we know that the Hurons had competent counsel. They had a well-developed decision-making structure. They can be trusted to make decisions in their own best interest, and Canada can assume that they are acting in their own best interest, because it's only in that situation that Canada could settle with them.
I'm not sure what the point of this is.
The point is to get at why Canada says that the Huron settlement was honorable. And as I said, Mr. Gover has conceded that on behalf of the contingent interest First Nations. I'm not sure that White Sand and Red Rock have conceded that the Huron settlement was honorable. And this is why I've gone through these arguments to demonstrate why it was honorable, because it was a negotiated settlement. And Canada can certainly view it as honorable.
Is there a difference in your mind between finding that particular settlement honorable and finding a comparison to it with another group honorable? So what has been in my mind, or the question that has been in my mind is, can this court know, or can Canada know, what the Hurons took into consideration when they reached a settlement, that they determined, if they did, that it was honorable for them to reach that amount?
Canada cannot know what led the Hurons to accept that settlement or to reach that settlement.
Or to what factors they considered?
No, Canada cannot know that.
Right. And the court cannot?
No, the court cannot either.
So is this test of honorability met with the superiors because you benchmark it against a Huron settlement?
I submit that the Huron settlement is honorable, and that should be without question.
Okay.
But
let's say it is.
Okay. Assuming then that the Huron settlement is an honorable settlement, that makes it an honorable benchmark for Canada to use in considering whether its compensation for the superiors is also honorable.
Okay, so that's the proposition that I ask you to help me with, the link. Let's take the broken ankle. If you settle with plaintiff A on a broken ankle, is that amount always the right amount for plaintiff B?
No, it's not always the right amount for plaintiff B. You have to look at their unique circumstances. And in this case, Canada looked at unique circumstances of the superiors. The fact, for example, that their needs are greater than the Huron plaintiffs, for example. So it's not just, take one settlement and squish it or impose it upon another. But it is a guideline. It's an honorable settlement that provides a guideline. And in that way, Canada viewed it as a useful validation exercise. The last point I want to make, I should just make a point. I just wanted to address an issue that also came up in your questioning of Mr. Schachter. I don't actually think it's relevant, but I do want to correct the record. At tab 36, page 2536 of the record is a letter from Mr. Schachter. Tab 36. Where he noted, and maybe we don't need to bring it up, maybe I can just remind you of it. He noted some concern about the population figures for the Hurons that the parties were using. And I noted, and Ontario did as well, that the population figures that the Crowns were using were based in 2024. But Mr. Schachter in his letter had made this question, had asked this question about, it appears that the population of the Hurons has jumped significantly between the stage 1 trial and now. The reason for that is, quite frankly, Canada's affidavits in the stage 1 trial that spoke to population wasn't really that clear because it totaled up numbers that didn't actually add up to what was in the attachments. And the lower figure that Mr. Schachter quoted in his letter did not include the Wikwemikong First Nation. So I don't think it's relevant, but I did want to, in case you did have a nagging doubt about
Sorry, at the stage 1 population figures did not include Wikwemikong?
The stage 1 population figure quoted by Mr. Schachter in that letter of 29,000 did not include Wikwemikong.
Thank you.
So it might, I understand, I'm happy to keep going, but I know other people might not be. So if we are to take a break, now would be a good moment. The next and last part of the RHT settlement I wanted to address was responding to Mr. Gover's submissions on the effect of the Supreme Court's decision on the landscape.
Thank you.
Shall we take the break and I'll come back to that?
Yes, thank you. Let's take a break, 15 minutes.
All right.
Or sit down for 15 minutes. This court is resumed. Please be seated.
Justice Hennessy, the next part of my submissions are to deal with the concerns that my friends raised about the landscape having changed after the Supreme Court's decision, which undermines the relevance of the Huron settlement, because the legal landscape had changed. The risks were different when the Hurons settled compared with, once the Supreme Court's decision came down. And the implication, and this point was raised, Mr. Gover addressed it in his submissions, but it was also raised in correspondence from the First Nations during the engagement and negotiation sessions. And it was addressed by Canada in Canada's December 20th letter, and then again in Canada's January 27th letter. We looked at and responded to head on the concerns that the First Nations raised about the legal landscape changed after the Supreme Court's decision. So the implication being that the Huron settlement, $10 billion may have looked good to the Hurons back in January of 2023, or February, March of 2023, but it wouldn't look good after the July 2024 decision of the Supreme Court. That's the implication. In fact, I would argue that it's the opposite, that the Huron settlement looked like a very good deal for the Hurons once the Supreme Court ruled that the treaty did not require mandatory augmentations without limit, but rather discretionary ones. So to address this argument, I want to look at page 37 of Canada's January 1st letter, page 49 of the record. And again, this is an issue that Canada had already responded to in its December offer letter, but we'll take a look at it in the January 27th letter. One of the remarkable aspects of the Supreme Court's decision, Justice Hennessy, was that all parties came away believing they had won. Certainly the First Nations felt that they won the decision because the decision found egregious and longstanding breach. On the other hand, Canada had admitted the breach, and even Ontario came around to admitting it before the hearing. That's noted in the Supreme Court's decision at paragraph 280. It must be acknowledged that Ontario's appeal was granted in part. The part that wasn't granted was its limitations argument. But on the issue of treaty interpretation, the Supreme Court held that the augmentation clause was not a mandatory obligation to increase without limit, but an obligation to exercise discretion. This was Canada's position at the stage 1 trial, in fact. So it wasn't that the Hurons were facing, with respect to limitations in particular, Canada had not even pleaded limitations, which I submit communicates the weakness of that defense. I submit that it was not a significant risk. As I know my friends have said, oh, the landscape changed because the poor Hurons were worried about the whole thing being knocked out on limitations, and this is why they took a deal that probably wasn't as good as they could have gotten until the Supreme Court said limitations don't apply. My answer to that part of it, Justice Hennessy, is the limitations argument was weak. Everybody should have known that. Canada didn't plead it. You had already determined that it didn't apply. The more serious risk.
I was never the last word on anything.
No. But I stand by my submission that the limitations argument was weak. And in my submission.
You tell that to the other emanation of the Crown? Or
well,
something?
At the oral hearing before the Supreme Court, and I think this is actually mentioned in the Supreme Court's decision, the limitations argument was barely touched on in oral argument. I shouldn't, without actually referring to the others who have read the decision, yourself included, might recall what I'm speaking of, but certainly in the Supreme Court, in the hearing, effectively, Ontario belatedly really did resile from that position. So the point is that the limitations argument was not as great a risk as my friends would suggest, particularly certainly from Canada's perspective. Canada didn't even plead limitations. So the real risk that the Hurons were facing was that when they settled, the real risk they were facing was that the treaty interpretation would be turned around by the Supreme Court, and the Supreme Court would find that there wasn't this mandatory obligation, that there actually was more Crown discretion. And in fact, that is what the Supreme Court found. So in my submission, after seeing what the Supreme Court did, its interpretation, the Huron settlement looks like a good one. Canada addresses these points, as I noted on pages 37 and 38 of its letter. I think I've made them, but I'll just go through them. Page 38 of Canada's letter, page 50 of the record, when we note, Canada notes that Canada considered the First Nations arguments on this point. It does agree that since the Huron settlement was achieved, the evidence of Stiglitz and Hutchings was trial tested and appears to have been well received at trial. However, similar evidence was available from the same experts by way of their written reports for the Hurons at the time of the Huron settlement. So the fact that Stiglitz and Hutchings' evidence was trial tested didn't affect the Crown's position on what the appropriate compensation that they would be willing to settle for would be. They already had Hutchings' evidence in the written reports. And to the point I've been making earlier, Justice Hennessy, is Canada doesn't necessarily agree that although Hutchings and Stiglitz, their evidence was trial tested, it didn't make it, some parts of it didn't hold up very well. The second
part that you relied on, the NCRRs, did hold up. And so that strengthened Canada's, you say, strengthened Canada's position to rely more heavily on it.
That's true. The second point, Canada does not agree that the Supreme Court's finding that the Crown's breach was egregious and that limitations defenses are not available significantly changed the risks for the parties from those they faced at the time of the settlement, as Canada had already admitted the breach and did not plead limitations. Similarly, Canada does not agree that the Supreme Court's interpretation that Crown discretion is not unfettered and can result in coercive remedies has increased the risk for Canada since the time of the Huron settlement. Indeed, the Supreme Court's interpretation of the treaty is consistent with the position that Canada took at trial and before the Supreme Court. And finally, Canada goes on to say that the Supreme Court, my friends had suggested that the Supreme Court decision identified this new head of damage called breach of the duty of diligent implementation, which attracts separate kind of compensation, and Canada has addressed that in its factum, that the Supreme Court said specifically that the breach of the duty of diligent implementation rose to the level of a breach of treaty, and they're one and the same.
When you make this argument, do you suggest that the Hurons were looking at two different crowns and two different sets of risks? Because when you say, and Canada didn't plead limitations and Canada didn't appeal, well, that has nothing to do with the risk the parties face if in fact another emanation of the Crown is doing something differently. The risk, I'm just saying you distinguish between them, but for the plaintiffs, they can't distinguish which of the two defendants takes a position. They just know that they're facing that position.
I give the plaintiffs more credit, Justice Hennessy. I think that it is relevant if one of the Crowns takes a position that, for example, limitations don't apply. I think that is a valid consideration in the for the Hurons to consider in assessing their risk.
Okay.
I'm ready to move to the engagement and negotiation process. And I had noted 3 items in particular that my friends raised that I wanted to respond to. One was that Canada dishonorably refused to agree to decision-making criteria or to enter into an agreement about the process. The other is that Canada did not send appropriate representatives who could truly negotiate and make compromises.
Okay.
And the third was that Canada did not debate or even discuss what my friend called the 3 big ticket items, or the main drivers of the gap. I actually think that that I can deal with pretty quickly. I think I've already taken you to parts of the record where you can see that Canada did engage with and discuss these issues, at the very least in its December 20th offer letter. But there are certainly other examples in the record where you can see that Canada, during those negotiation sessions, addressed those issues head on. And I'll just, without taking you to them in the interest of time, I'll just refer you to parts in the record where you can see that. One is at tab 8, Canada's letter of September the 10th. When the process began, counsel for the First Nations, Mr. Schachter, sent a letter outlining these 49 foundational elements for the engagement process. And Canada responded to that letter on September the 10th. Canada's letter's at tab 8. It's a lengthy letter that goes through those 40,
Tab 8.
tab 8 of the record.
Thank you.
Yeah. Page 1204. So 1,204 of the record. And that's in response to the First Nations letters of July 30th and August 19, where they proposed the 49 foundational elements for the process. Canada responded to those 49 elements, and in that response addressed some of the issues on economic rents, for example. And another example would be the meeting minutes from November 18, which you will find at tab 106.
Always of the record.
Always of the record, yes. Tab 106 of the record. At page 3,870, it's noted that I personally, on behalf of Canada, went through Canada's submissions at the stage 3 closing, which centered on NCRR over rents, bring forward and share. So these issues were certainly discussed during the engagement and negotiation sessions. So I think the more contentious issues are the two that Canada dishonorably refused to agree to the decision-making process or to enter into an agreement about the process, and that Canada did not send appropriate representatives who could truly negotiate. So I just want to address those two.
Okay.
And there were two proposed agreements that the First Nations Council submitted, and one is found at, again, looking at the record, tab 12, which is as an appendix to a letter dated October 1st. Starting at page 1,239 of the record, there is on the screen now the agreed upon decision-making criteria. And the other is the annuity augmentation engagement agreement, the proposed agreement that my friend Mr. Schachter took you to. You can find that at tab 19A of the record. So I just want to look at, for example, Canada made the point in its factum that these documents were seeking Canada's agreement on substantive issues, not just procedural issues, but in many cases, substantive issues. And Canada did agree where possible on certain substantive issues, such as it was not pleading, it would not plead limitations, that the period to be covered would go back to 1850, despite the fact that Supreme Court had directed the Crown to determine compensation from 1875. Also, that Canada would use the population numbers most favorable to the First Nations, which were developed by Professor Bignami on her low growth scenario. Those were the highest numbers. So these kinds of substantive things where Canada could agree, it did agree, but there were some issues that the First Nations sought agreement on that Canada was not in a position to agree to at that time of the process, and in some cases or at all. And so just by way of example, let's turn the page to 1,240. You can see, for example, the types of things that my friends, the First Nations, were seeking Canada's agreement on was that number 5, in deciding on the quantification of past compensation, the nature and severity of past breaches will be taken into account in the following ways, and then lists a number of different categories of compensation, including compensation for aggravated damages, for the failure of diligent and purposeful fulfillment, full indemnity for all costs, constitutional vindication, constitutional deterrence, punitive damages, a further top up to the First Nations in recognition of the emotional hardships. Many of these things overlap with one another and are not well defined as you read through. As you read through this proposed agreement, many of these types of compensation are not well defined. They overlap with one another, and they include things like constitutional vindication and constitutional deterrence, which, as I've explained to you, Justice Hennessy, Canada does not view those as separate heads of damages. So these are the kinds of things that Canada could not agree to at the time. That doesn't mean that the process was unfair. Another example at 1,242, this was with respect to how the Crowns would consider the number of Superior Anishinaabe and their needs, factor 2. And the First Nations sought the Crown's agreement that the parties shall seek to identify and quantify the financial costs of the present needs of the RST Anishinaabe. The parties will seek to identify the quantum of monies needed today to secure such things as economic sovereignty for the First Nations, infrastructure requirements, including, for example, buildings, roads, bridges, docks, etc., municipal and infrastructure costs. Canada was not in a position to be able to agree that the parties would seek to identify that quantum of monies when we were in a time-bound process. And remember, the Supreme Court gave the parties 6 months. As it happened, the first month was August, and December also intervened. So it was a very tight schedule. And just the last one I want to refer to is at page 1,245. The First Nations sought the Crown's agreement that economic rents is the appropriate means of quantifying the benefits the Crowns received. And Canada just does not agree with that approach. And so these are examples of substantive issues that the First Nations were asking the Crowns to agree to, not just procedural issues. These aren't really properly defined as decision-making criteria. So it's not, and it was not dishonorable of Canada not to enter into these agreements. The other agreement was at, as I said, 19A, this proposed annuity augmentation agreement. I won't go through that as well, but I submit that when you do, Justice Hennessy, you'll note that large parts of it as well are substantive in focus. And the issue to consider here is this draft agreement was provided, you can see from the letter, the email accompanying it, October the 7th, at which point we had even fewer months in order to negotiate, and Canada expressed its view that it wasn't a good use of time to be trying to agree on an agreement as opposed to just getting down to, excuse me, the negotiation and the engagement in negotiation on the 5 factors. Now I want to address the argument my friends made that Canada did not send representatives who could actually negotiate or make concessions at the table. And I just have a few documents I want to refer you to on that. The first is, again, at the record, tab 64. This is a letter from the chiefs directly to the 2 ministers, the federal minister and the provincial minister. And the chiefs state on the second page of their letter of July 29th, it's at page 3,584 of the record, and it's on the screen now. The First Nations say at the bottom of page 2, we expect that the Crown will appoint fully authorized senior negotiators who will have the ability to seek timely mandates directly from their ministers to resolve the issues that arise in negotiations. And I note this simply because the chiefs acknowledge that that the ministers would have to send senior representatives. It wouldn't necessarily be the ministers themselves who would be attending. And in response, Minister Anand Sangari at tab 73 wrote back, this is page 3,620 of the record, wrote to the First Nations chiefs first to thank them for hosting him at Old White Sand on September the 15th. And he went on to say at the end of the 3rd paragraph, I can assure you that Canada remains committed to engaging in meaningful and honorable discussions with the Robinson Superior Treaty First Nations. I am receiving regular updates from Canada's negotiator, Jeremy Morrison, and his team. I am confident in their ability to continue working collaboratively with you over the coming months. This represents Minister Anand Sangari's confidence in the lead negotiator that he had appointed. Mr. Morrison is a lead negotiator for Crown Indigenous Relations. He's not a lawyer. And he was in attendance at all of the negotiation and mediation, or the engagement and negotiation sessions, and of course the mediation. So the next document I want to take you to is the minutes of October the 8th, which are at tab 96 of the record. At page 3,722, these, as I said, are minutes of the October 8th meeting of the parties, including 5 chiefs and Councillor Bouchard from Pays Plat. Jeremy, who's Jeremy Morrison, Canada's lead negotiator, Jeremy stated that he is appointed by the minister to represent him. And while Canada does not have a position on everything yet, they still want to hear from the First Nations. Jeremy views his role at the table as someone who will listen to the First Nations and express the views of the Crown. But is not in a reality where he can answer in an instant. Even if the minister was here, Canada cannot make certain concessions. Those decisions are made at cabinet. So what's being communicated here, and it's articulated in our factum as well, is that Canada's representatives were not able to make billion-dollar decisions at the table. Those required consultation with the minister, and in some cases with cabinet, the ultimate decision maker. And it was not dishonorable for Canada to come to the table with representatives and have to take issues back. In fact, this is the same process that the First Nations used. The First Nations had a process team, which had a limited mandate, and they often had to seek caucuses so they could call other chiefs. Including, for example, on that issue of whether the First Nations were unanimously taking the position that the annuity was not an individual entitlement. I won't take you to that, but I can give you the reference. It's in our factum, but it's referenced to page 3,872 of the record. And I don't think I need to go to it, Justice Hennessy, but our factum makes the point that the First Nations had sent a letter explaining that their process team had a mandate to discuss certain things about the process, but those 5 chiefs and 1 councillor did not have the authority to make all decisions on behalf of the First Nations in the same way that Canada's representatives didn't either. And my submission is that didn't make it for a dishonorable process. It was an honorable process. Unless you have any questions, Justice Hennessy, about the process?
Actually, just want to catch up on this last point. The point is one, or I think you make maybe 3 points. One, Canada sent senior Crown representatives who had the confidence of the minister and updated the minister.
That's correct.
So says the minister. That it's not realistic to expect that some decisions could be made at a table by any representative, including a minister.
And including the First Nations representatives. Some issues.
Well, I'm not there yet. And that the First Nations process, to some extent, mirrored the Crown process, that they had representatives who had to go back to others for authority on certain questions.
That's right.
Those are your points.
That's right. And the First Nations letter about their process team is at tab 10 of the record.
Okay.
For your reference, we do refer to it in our factum. I note as well, of course, that there was an engagement and negotiation process that, as noted in the record, there were, I think, 27 meetings, 18 of which were in person over that time period. And at the end, then Madame Charette, who had been the facilitator for these meetings, at the First Nations request, was then retained to be a mediator, and the parties went through a mediation, which included the ministers were in attendance at that. So all that together, Justice Hennessy, demonstrates that it was an honorable process. If you don't have any other questions on the process issue, I would like to move to Crown allocation. A couple of points to make. First, Canada and Ontario obviously took different approaches to arriving at their compensation of $1.8 billion each. The fact that Canada has described in its letter how it came to its determination, it's very different from the way that Ontario came to Ontario's determination, which is indicative of the fact, in fact, I would say it proves that Canada exercised its discretion independently of Ontario. Mr. Schachter asked during his submissions whether Canada's $1.8 billion was truly based on 50% of $3.6 billion, or whether it might have been based on 20% of $9 billion, given that Canada had previously taken the position at stage 3 that its liability should be no more than 20%. Mr. Schachter raised this possibility in his submissions. Canada is very clear in its January 27 letter that its $1.8 billion determination of compensation is based on Canada's overall assessment that $3.6 billion is an honorable amount of compensation, coupled with Canada's determination that honorable dealing with the First Nations requires it to pay 50% of that. That is how Canada came to its calculation. But at the same time, Canada has made it clear that it maintains its position that Ontario bears greater liability to the First Nations since it collects the resource revenues. Canada expected that Ontario would exercise its discretion independently. It is fortunate that Ontario determined that it would also pay $1.8 billion.
Fortunate?
It is fortunate.
To whom?
It is fortunate to the First Nations.
Oh.
And of course, I will leave it to Ontario to explain how and why they arrived at that figure. But if this court were to determine that the overall honorable amount of compensation should be greater than $3.6 billion, then Canada maintains its position that Ontario should pay the greater share. This leads us to the...
I have a question on that. You say if the court imposes a number that is greater than 3.6 billion, you say Canada would not take a position of a 50% share.
That's correct.
So this notion of parity or not having significant differences with the Huron settlement, which was paid out at a 50% share, would not be a guiding principle for Canada. This importance that Canada has placed on the Huron settlement as a benchmark would go out the window because the number was not what Canada determined it should be?
I'm not sure I understand your question. Are you noting that in the Huron settlement, Canada also agreed to pay 50%?
Yes. So my understanding of the Huron settlement, there are two elements. There's an amount, 10 billion. That's one dispute. That's a dispute that Crowns have with the First Nations. And there's a second position that Canada took, and that was a position vis-a-vis their dispute with Ontario, that it would pay 50%. That's a position Canada took to resolve that
It was a settlement.
that claim.
It was a settlement position that Canada took.
That's right. And so was the 10 billion.
Yes.
Those were settlement positions. You reached a resolution. And when you got to the superior settlement offers and determination, for whatever reasons drove Canada, you came up with a 50% share as the resolution, I'm not saying it's honorable. It doesn't have to meet any test of honorableness because it's as between two crowns. It was whatever it was to Canada. That was the position you took. And that position, I have never heard until today, that position vis-a-vis your adversary on allocation was in any way related to the amount that Canada determined was an honorable amount to the First Nations.
Where Canada addresses this is in its December 20th letter, when Canada said its offer at that time was conditional on Ontario either matching or exceeding that amount. So Canada's determination was made independently on the basis of Canada's assessment of 3.6 billion as the total, coupled with Canada's determination that the honorable thing to do in the circumstances would be to pay 50% to the First Nations. That doesn't mean that Canada is conceding vis-a-vis Ontario that Canada's liability is 50%.
I get that. Canada has taken the position, it's not conceding anything. But now I'm talking about Canada's dispute with the superiors. So you say that your resolution position with Ontario, first with the Hurons, and secondly with the superiors in the process that's under review, would not influence you or bind you in any way if there was a change to that number, to the compensation number.
I think that's right, Justice Hennessy, because Canada has explained that its determination to pay 1.8 billion was based on two different factors. One being the amount of a global amount of 3.6, and the other being Canada's determination that in the circumstances, 50% would be the honorable thing to do. But there's both components to that decision. So I think it is fair to say that if the amount awarded was more than $3.6 billion, in Canada's view, $3.6 billion is the honorable amount of compensation. It's an appropriate and honorable amount of compensation. If this court were to find that it isn't and it should be more.
If this court were to find it was 3.7 billion, you'd say we're out of the 50%. We're now going to make this a fight with Ontario, saying we're only in for 20%. Good luck, superiors. Watch us fight.
Justice Hennessy, at that point, Canada will do what the court directs it to do, clearly. But Canada's position is that its determination is to pay 1.8 billion. That's it. Canada believes that 1.8 billion is the honorable amount of compensation for Canada to pay in the circumstances, independently of what Ontario pays. That's Canada's determination of its honorable compensation. It's based on Canada's assessment of 3.6 and Canada's assessment in the circumstances, 50% of that would be appropriate. But overall, Canada's assessment is 1.8 billion. And Canada maintains the position that no matter how you look at the situation, we have to have a rational explanation for how we came up to our number. And Canada...
Just one last question. So first of all, I'll just leave this for you to put in your back pocket to get to some other time. But you described this position, Canada's position, as honorable. And you are consistent with using that term. I never hear you say liberal. But I'm just putting that out there because the Supreme Court said honorable, liberal, and just. But let me go back to this notion. So you say that the dispute between Canada and Ontario is something that the superiors will have to live with continuing, even on the question of past compensation. If it is, and I'll put this to you, $1 more than Canada has determined is honorable.
I think you're raising a hypothetical that I have trouble following because I don't understand in what circumstance that Canada would be placed in that position. But I think what you're getting at is, would Canada pay 50% of a higher amount? And my answer to that is Canada's determination of honorable compensation, which is liberal. Honorable means liberal. And I haven't been using the word liberal. We do use the word generous, and Canada uses the word generous in the January 27th letter, but it's an oversight that I haven't been characterizing it as liberal. Canada's honorable and liberal compensation is $1.8 billion.
Okay.
My colleague has asked, are you asking if Canada would try to claw back and pay less than 1.8 billion? Certainly not.
No,
I don't think that was part of your
not
question.
asking that.
But here's where we get into the Crown allocation issue. My friends had argued at stage 3 that liability between the two emanations of the Crown should be joint and several. And you will recall from the stage 3 arguments, Canada's position is there is no basis in law for joint and several liability. Joint and several liability is a private law concept. We see it mostly in tort. It's provided for under the Negligence Act. We see it in contract, where contracts specify that parties will be jointly and severally liable, but it's a private law concept that does not apply in the public law or to the Crowns. And Canada has cited the Grassy Narrows decision for the proposition that each emanation of the Crown owes unique duties directly to the First Nations. That's the Grassy Narrows decision. So given that Canada's submission is there is no joint and several liability here, each Crown owes their own obligations directly to the First Nations. Canada is saying it acknowledges it owes obligations directly to the First Nations. Canada's always taken the point that the future is something we can't address yet, because we don't even know what the resource revenues will be or which emanation of the Crown will collect them. So we're not talking about the future. We're just talking about the past. And Canada says in respect of the past that given that the revenues were mostly, almost entirely, if not entirely, collected by Ontario, Ontario should bear greater liability. Canada nevertheless accepts it has unique responsibilities to the First Nations. As we explained at stage 3 trial, and I mentioned again yesterday, one of those obligations was Canada should have followed up with Ontario and said, what are your resource revenues? Should have followed up, should have engaged in a process with the First Nations to determine when augmentations were due. That's where Canada comes up with this 15 to 20% liability, right? So, and Canada maintains that position. So in determining what is honorable and liberal in this case, Canada's unique obligation to the First Nations, independent of what Ontario does, Canada's unique obligation is $1.8 billion. And Canada has shown its rational chain of analysis as to how it comes up with 1.8 billion. That happens to be based on a decision that 3.6 is the total, Canada will pay half. But overall, Canada's position is what Canada's done is come up with a rational way to determine what its unique responsibilities are to the First Nation. And Canada liberally determined, in fact, we use the word, I believe Canada uses the word generously, determined that the generous response would be to pay 50% of this amount. Does that clear it up?
No, I think I may have mixed it up. Let's try this. We come here in this process for a review of Canada's determination of honorable past compensation. And Canada's position, there are two unique disputes, separate disputes, one with the First Nation for Canada, one with the First Nations, one with Ontario. But what happens is Canada makes their determination for past compensation and bases it on a solution, on a resolution with their dispute with Ontario, and says 50%. And for whatever reason, Canada made the same determination, the same resolution in their dispute with the Hurons. And that past compensation would be addressed on a 50-50 split with Ontario. So one might say that Canada doesn't need a decision on Crown allocation for the past. And Ontario, in a discussion about this at the case management conference, Ontario said it's precedential value. And I may have said, I think I said something, so for the future, and there was an agreement that the basis for a reminder to the court that a Crown allocation decision was required was for the future. And one might find that that makes sense because the parties had settled past compensation with one group and had determined past compensation with the other territory, and Crown allocation was decided. And you say, I think you're saying now, that for past compensation, if the amount changes, the split with Ontario also changes.
I think that's a fair summary. And to give some more context to this, Justice Hennessy, you know, on the one hand, you might decide that the Crown allocation issue with respect to the past is moot because Canada and Ontario have both agreed that they're going to split, that, you know, Canada has said, at least Canada has said that it'll pay 50%. So you might have concluded, well, perhaps the Crown allocation issue, because it only deals with the past, is moot.
Or
but
Crown allocation for the past.
Yes. But I would say, Justice Hennessy, it's not moot for two reasons. One is
not moot for past compensation.
That's right.
Okay.
Canada's always taken the position that the Crown allocation issue does not resolve the future at all. Canada's been consistent in that position. It took that position at the stage 3 trial. Ontario disagreed. Ontario, of course, took the position that it's 100% Canada for the future as well, right? Canada's always taken the position that the Crown allocation issue can only be determined with respect to the past because it's based on the Section 109 argument about the lands, right? The resource revenues having gone to Ontario. So I'm only talking about Crown allocation for the past. And so where you're concerned, or there has been a concern about precedent for the future, Canada is not asking you to make a decision on the future, and Canada would say, there won't be any precedential value to that decision. We're just talking about this circumstance in the past.
Well, how does a Crown allocation decision not have an effect on the future?
I'm not going to finish by 12:30. Yeah, I'm sorry.
That's all right. No, this is all about my interventions. Go ahead.
I haven't made the point that I wanted to make, and I hope that I don't forget it. But to answer your question about why it has you'll see in Canada's factum, the only answer that Canada wants on Crown allocation is your determination that it's not joint and several. That's the order that Canada is seeking. Okay. At the stage 3 trial, when you look at Canada's submissions, Canada was seeking a decision that Canada's liability for past compensation should be 15 to 20%, and that the responsibility is not joint and several. Now, Canada is only seeking the declaration that liability is not joint and several. That will have precedential impact, not just on this case, but on other cases. That aspect does have precedential impact. That's the issue Canada Canada believes can be determined. We haven't gotten to why I think can be, because you asked that question about, is the issue stayed? Canada, shall I go to
Oh,
that?
yes, go ahead.
Yeah, you had asked the question, did the Supreme Court actually stay this entire issue because they issued a stay on the stage 3 trial decision and then said, here's how the proceeding is supposed to carry forward? Does that mean that the issue of Crown allocation has been stayed? And Canada says no, because of the factors that Canada had to consider in determining its assessment of compensation. There were the 5 factors that the Supreme Court set out, but the Supreme Court said that those aren't exhaustive. And another factor that Canada considered in exercising its discretion was its share vis-a-vis Ontario. So
Do you say that in the letter?
we absolutely say that Canada determined to pay, that it was honorable and to pay 50%. So that is how it came up with its determination.
Okay, thank you.
So here I'm just getting to the issue. There's 2 parts to Crown allocation. Can you decide the issue? Should you decide the issue? And the first part, I'm saying you can decide the issue. I submit that the Supreme Court did not stay the issue. They knew that Crown allocation was a live issue. It is a factor that certainly it's apparent and transparent that it was a factor that Canada considered in its determination of 1.8 billion. It considered its share with Ontario and determined it would be honorable in the circumstances.
When you say they knew it was a factor, the First Nations?
Sorry, the Supreme Court. The Supreme Court knew that Crown allocation was a stage 3 issue.
Oh, okay. They knew it was a stage 3 issue. Yes. I thought you said they knew it was a factor that that Canada considered.
Oh, I'm sorry. In that case, yes, I meant the First Nations. The First Nations knew that Crown allocation was a factor that Canada considered in determining its amount of compensation. That's clear in its December 20th letter and in its January 27th letter.
Okay.
And, you know, I've characterized that as an additional factor, but it really fits within factor 5, which is the principles flowing from the honor of the Crown. That's the way Canada approached it when Canada determined that it would be honorable in the circumstances for Canada to pay 50%. Here's where Canada is attempting to be liberal, to say, look, we have our unique obligations to the First Nations. Our fault was in not following up with Ontario on its resources. And we've determined compensation should be 3.6 billion. Canada has honorably and liberally determined that honor requires it to pay 50% of that. So that's really part of factor 5, the honor of the Crown. And so I'm getting into this issue in order to make my submission to you that the Crown allocation issue is still alive and can be determined.
Or past compensation.
Past compensation. And I'm sorry that
Trying to figure out how a decision on Crown allocation for past compensation is not moot. If in fact, for instance, this court determines that the amount set by the Crown was liberal, honest, and just.
it is moot. If the court determines that the 3.6 billion is liberal, honorable, and just, it is moot because Canada has agreed to pay has already paid the 1.8 billion. Canada's not, absolutely, if this court determines that 3.6 billion is the right number, the whole issue of Crown allocation, other than joint and several, is moot.
You say joint and several issue is still alive.
Yes,
For past compensation, if,
not for past compensation, not for past compensation.
that's my question.
Okay. I understand your question. It's not, it will be, joint and several will be moot for past compensation. If the court decides that 3.6 billion is honorable, liberal, just.
But not if it determines if it's $3.61 million and imposes that as the honorable number that should have been
Yes,
determined by the court.
that's correct. If this court were to determine that a larger amount of compensation is, that $3.6 billion does not fit within the range of honorable results, and the result needs to be something greater, then Canada's position is that Ontario should bear that additional liability. So if I can summarize that in Canada's submission, you can decide the issue of crown allocation because it hasn't been stayed. It is relevant to the 5 factors. It's relevant to honor of the crown. So you can decide
I
it.
just have one last question on this. And you say that for Canada's purpose, the only issue that Canada wants determined is the joint and several question. That is not the only issue that Ontario wants determined.
And I also realize that if this court were to find that there was a larger compensation to be paid, then Canada says you do need to determine crown allocation because we submit to you that Canada should not be liable for 50% of a larger amount. And where we come to this is Mr. Schachter's suggestion when he said before, what if the court decides that $9 billion, he didn't put it this way, he said, what if Canada decided that $9 billion was the appropriate amount and 1.8 is really 20%. Let's use that idea. Let's say that the court were to decide $9 billion is the honorable amount. In Canada's submission, $1.8 billion is still honorable on behalf of Canada. And in that respect, if you were to make that determination, then you would have to decide the crown allocation issue, and Canada submits that you should decide it by determining that Ontario is responsible for more. And this fits in with what Canada said in its December 20th offer when it said Ontario, it was conditional on Ontario matching or exceeding the amount. Ontario maybe has its own obligations to consider. Grassy Narrows tells us that it's got its own responsibilities, and how Ontario comes up with its number and its responsibility is separate from Canada's.
Let me just make sure I understand this. You say that should the court not disturb the amount, then the question of crown allocation for past compensation is moot.
That's correct.
Should the court find that the amount is not liberal, honest, and just, liberal, honorable, and just, and impose a different amount, then there is no then the crown allocation question is fully open, and Canada does not take the position that it should pay 50%.
Exactly. Took us a long time to get there, but that's how to sum it up. That's correct.
I'm just going to put it down so I don't forget it. So just to make sure I've got it. Should the court find that the compensation determined is liberal, honest, and just, Canada says the Crown allocation question is fully moot or past compensation. But the question is fully open if the court imposes a new amount and Canada then relies on its arguments that they should only be liable for 15 to 20%.
That's correct.
Okay, thank you.
Now, regrettably, there is a little wrinkle, which is when I go, of course, the orders Canada requests, even if the issue is moot, the division of the allocation of liability is moot with respect to the past, because the court determines that 3.6 billion is honorable, liberal, and just. So I've said, yeah, the Crown allocation for the past is moot. Except that Canada still maintains that this court should make a determination on the joint and several liability point. And that is something that is a foundational principle, I would suggest, that is not tied to whether we're talking about the past or the future. It's a foundational principle that the First Nations have asked to make a finding that liability is joint and several. Canada is asking you not to make that finding. And that does have potential precedential impact in the future. But certainly with respect to percentages of Crown allocation, the issue for the past is moot if this court were to agree that $3.6 billion is the right amount. So I'm ready to turn to costs, but I'm very conscious of the time. The only thing I'd like to do, Justice Hennessy, is just take you back to page 3034 of the record. We looked at this yesterday, but I think it might help summarize this point, which is Canada's December 20th letter, where Canada explains its position vis-a-vis Ontario. And where Canada says, Canada has determined the amount of compensation it is offering based on Canada's own assessment of the compensation owed and with the purpose of addressing Canada's unique obligations. And this is where, previous to that, Canada had said its offer was 1.5 billion. Canada expects that Ontario will conduct its own assessment of the amount of compensation that it owes in order to discharge its unique obligations. And goes on to say that Canada's offer was conditional on Ontario matching or exceeding. So this is where Canada is communicating that its assessment is conducted solely on what Canada's responsibility is.
Thank you.
So I really am disappointed that I was unable to finish before lunch, because I know we're on a tight time schedule now that council have asked not to sit on Friday. And I don't want to be shortchanging Ontario.
What do you say is the time required for you to deal with?
I think I can do costs in probably 20 minutes.
Okay. And orders?
Orders is 2 or 3.
Oh. So the question is, should we go till 1 and take a shorter lunch break?
I'm fine with that, but I people may be tired of listening to me. Taylor?
We can do it at this side. Everyone else?
Thank you very much. All right, on costs. The first thing I want to address is just I want to address comments Mr. Schachter made on the record that may have been a little bit misleading. Mr. Schachter did concede that Canada prepared its January 27 letter and its decision to pay $20 million in costs before it received information about his $100 million counsel fee. Mr. Schachter has conceded that. Nevertheless, Mr. Schachter said on the record that he'd seen a draft of the January 27th letter, and it was a different letter than the one that came out on January 27th. And I want to correct that. What happened is, you may recall from the case management conferences, and it's included in Mr. Schachter's factum as an appendix, Canada had promised to provide a list of documents over which the Privy Council office indicated that Canada claimed confidences of the King's Privy Council. As a result of that process, there was one document that was released in a redacted form. It was a briefing note from the Deputy Minister to the Minister, which attached the draft January 27th letter, and it was dated January 24th, and it has been provided to my friend. So he saw the January 27th letter in its draft form. Mr. Schachter said on the record that it was a different letter. There's only one difference between the January 24th draft and the January 27th final, and that was the insertion of a phrase regarding the 25% tariffs, the US tariffs. We're going to discuss this factor 4 and discusses the fall economic statement. There's a phrase in there about, and there is this threat of 25% tariffs, as we know at the time, threats on, threats off. That is the only difference between the draft and the January 27th letter. I just wanted to correct that for the record, because I didn't want you to take away some impression that Canada changed its approach in any way between the 24th of January and the 27th of January. The other point I'd like to make is Mr. Schachter's letter, where he disclosed the $100 million counsel fee, is included in the record, but it's not time-stamped. I can tell you it was received at 9:07 p.m. on Friday, January the 24th. We've already advised that the First Nations information about costs was received after hours, and some of it on the Saturday, the 25th. But Mr. Schachter's letter in particular, which disclosed the $100 million counsel fee, came at 9:07 p.m. on Friday, January 24th. So there is no doubt that when Canada determined to pay $20 million, it was not aware of the $100 million counsel fee.
But it's not the 20 million that Mr. Schachter is relying on. It's the or costs as assessed, or is there some extra phrase?
So, and what I was going to say is this isn't really even that relevant, and Canada didn't scramble to change its letter once it received word for the first time of this $100 million counsel fee. Canada didn't scramble to change its letter because its January 27th letter already indicated that Canada was not agreeing to pay more than costs that would be assessed, court costs that would be assessed in the usual process, the usual under the rules of civil procedure, the usual process. Canada said
was not agreeing to pay.
Canada was not agreeing to pay an amount that is over and above what would be assessable under Rule 57.
Oh, was not agreeing to pay an amount over.
That's right. So let's take a look at exactly what Canada says at page 17 of its letter. Justice Hennessy, let me just back up and say that repeatedly, Canada asked the First Nations during the engagement and negotiation process, give us a ballpark figure for your costs. And this is noted in our fact, and we have a number of cites to the record in the minutes where Canada or Ontario asked, give us a figure. What is your ballpark figure? What are your costs? When can you tell us your costs? And Canada received absolutely no information whatsoever about the First Nations costs. And it might be understandable why some of the First Nations would say, well, we don't really know quite exactly yet when, we're still working on it. But I submit, Justice Hennessy, it is inexplicable that Mr. Schachter would not have advised the Crowns that he had a $100 million cost agreement with his counsel when he had ample opportunity to advise the Crowns of that. Unless he came up with this $100 million agreement at the very last minute, the Crowns should have expected Mr. Schachter to disclose to them the $100 million. Instead, Mr. Schachter asked the Crowns to agree to full indemnity as a principal without telling the Crowns what it meant. And Canada first said, Canada agrees that, the cost should be recoverable. And Mr. Schachter wrote back to say, well, we're very happy to hear that you agree to full indemnity. And Canada wrote in its January 27th letter, hold on. Canada wishes to clarify its position. Canada has not agreed to fully indemnify each First Nation. And remember, this is written before we saw the 100 million. For all of its costs, including all of its legal costs, as set out in the January letter. In that letter, the First Nations suggest that legal costs are, quote, significantly greater than what a party might be obliged to pay on an assessment of court costs. Canada does not agree with this statement. What Canada is saying is Canada does not agree to pay costs that are significantly greater than what a party might be obliged to pay on an assessment of court costs. So Canada is making this point now. Canada will pay.
Can I just ask, is this the
January 27 letter?
It's the January 27 letter.
Yeah.
Thank you.
And it's in a response to Mr. Schachter's January 6th letter, which I'm not going to pull up. It's at tab 50, tab 50. I won't pull it up in the interest of time, but it's quoted here. Mr. Schachter says, well, thanks, Canada, for agreeing to indemnify the First Nations. Of course, for agreeing to pay legal costs. Of course, that means legal costs that are significantly greater than what a party might be obliged to pay on an assessment of court costs. And Canada says, whoa, that's not what we meant. We don't know what you're getting at, Mr. Schachter, because you haven't told us, but we're not agreeing to pay significantly greater than what a party might be obliged to pay on an assessment of costs. Canada's position is that it will pay reasonable, assessable costs. And the $100 million does not fit into that category. Mr. Schachter himself acknowledges this when he characterizes that $100 million as significantly greater than what a party might be obliged to pay on an assessment of court costs.
So let's just say, or let's just go back to what Canada has agreed to. And you say you've agreed to pay for reasonable and accessible costs. And you say that that's a Rule 57 assessment as opposed to an assessment of a counsel fee. Is that your real dispute? Because I believe Mr. Schachter says, well, it's $100, it's up to 100 million on reasonable and accessible. Or it's up to it.
Yeah.
That what the First Nations were proposing was that they were seeking or said they had an agreement on a counsel fee, but they were content that be assessed. So is the dispute between what type of assessment Canada was agreeing to?
Canada can only agree to one type, and you've raised a good point. There are two types of assessments at play, Justice Hennessy. There's a Rule 57 assessment, which is a party and party assessment. That's as between the plaintiff and the defendant. What is the defendant required to pay? That is entirely different from a solicitor and his own client assessment under the Solicitors Act. Canada has no standing to participate in that assessment. The assessment of whether $100 million is a fair and reasonable counsel fee is an issue for the Solicitors Act for assessment as between the solicitor and his own client. And Canada has no standing to participate in that. And I've got case law to direct you to.
Let's say I'm familiar with that.
All right.
Let's just put that aside. Whether you have standing. I don't think the question was what Canada would do at such an assessment or whether Canada would take a position at such an assessment. I thought it was trying to have Canada agree up front that whatever was assessed.
Well, and
that
here's
they were
where
offering to pay.
the court notes the perverse incentive here. The Supreme Court, I've got a Supreme Court case that I'll direct you to, notes there's a perverse incentive here that it's up to White Sand and Red Rock to challenge the $100 million counsel fee if they don't want to pay it. And if the court decides, oh, well, I have this have the counsel fee determined in a separate proceeding in which Canada cannot participate. Have that determined in a separate proceeding. And then Canada, if it's determined in that proceeding to be fair and reasonable, then Canada will have to pay it because it's being determined to be fair and reasonable. But there is no incentive whatsoever for White Sand and Red Rock to challenge the $100 million counsel fee if they know it's going to be paid by the Crown. This is a fundamental problem with requiring defendants to pay premiums that they have no reason to expect and can have no influence over.
Well, it might be a fundamental problem, but it's an acceptable part of the system in class actions.
Class actions are different though, because
you can distinguish class actions, but it is a part of the system in class actions where the defendant who is paying goes to the court for an assessment of what's fair and reasonable.
yes, but that's the why class actions are different is because certainly under the rules, the rules are transparent that counsel are entitled to a multiplier. That's the system, that counsel are entitled to a multiplier, and it's the court that will determine what multiplier is appropriate. And that's an issue. First of all, the defendant has an expectation that they'll be paying a multiplier and that the court will be reviewing it. That's an issue as between parties. Here, we've got a situation where as between counsel and their own client, they have a special agreement for a premium that Canada has no knowledge of, even when there was ample opportunity for it to be given knowledge of, had no knowledge of at all. And so that is a way in which the class actions regime is different. And let me take you to the case law on the problem with these kinds of extra amounts. Now, the case law, of course, acknowledges that over the years, the cost regime, the cost rules have changed, and these cases are from 2006 and 2007 under slightly different emanations or versions of costs.
Well, let's say I have recently read the decisions by Justice Myers and Justice Perel on these questions. They are much more recent.
On questions of risk premiums?
On questions of counsel fees in class actions.
In class actions, which I submit to you is entirely different, Justice Hennessy.
I thought that's what you were bringing to me.
No, I'm bringing you to Walker and Ritchie. It's a 2006 decision of the Supreme Court of Canada.
Oh,
It's not, these are,
cases on costs.
yes.
Thank you.
And it's not in our factum, but I did provide copies to the court electronically on Monday. So the first decision I want to come to, and I've got two of them to take you to, this one is Walker and Ritchie, 2006 of the Supreme Court. You've got the site there. It's 2006 2 SCR 428. Now, this decision was based on the cost regime that was before contingency fee arrangements were permitted in Ontario. And so the practice of counsel was, instead of seeking a contingency fee agreement, they would seek a risk premium, which in my submission is very similar to this idea of a counsel fee. There's the risk that you won't win, you won't collect any costs, and in exchange for taking on that risk, for the risk of not being compensated for X number of years, this risk premium I submit is comparable, if not identical, to the $100 million counsel fee. So the Supreme Court, what happened here was the trial judge ordered that there be a risk premium, and the issue was whether the plaintiff's cost award payable by the defendant should be increased to take into account the risk premium. So we'll assess your costs under Rule 57, and then we'll add to it this risk premium. The Supreme Court held that the trial judge's decision to include the risk premium in the costs to be paid by the defendant should be set aside, partly because one of the factors under the Rule 57 cost scheme which wasn't enumerated then but is now, is one of the factors to consider is the expectations of the defendant. The defendant had no knowledge of this risk premium or no expectation about it. And so at paragraph 27 of the decision, the Supreme Court says, parties to litigation have knowledge about the nature of the case and can control their own conduct in the litigation. Therefore, the parties are capable of predicting generally how such factors would affect a cost award against them, and may thereby be guided as to whether or not to settle or to proceed. By contrast, a risk premium is a financial arrangement between the plaintiffs and their counsel. It is not a matter about which the defendant would normally have knowledge, nor is it a matter about which the defendant is entitled to know. And the court goes on to paragraph 29 and quotes the Court of Appeal below, who said this with respect to risk premiums. A defendant has no knowledge of the private arrangements between the plaintiff and his or her counsel, and thus no means of measuring the risk of engaging in litigation. Defendants would be unable to gauge their exposure to costs when deciding whether and how to defend, as exposure would be dependent, at least in part, on the financial means of the plaintiff. This difficulty would be compounded by the fact that many plaintiffs would happily agree to any amount of premium if the premium were to be paid by the losing party. In situations where a party realistically understands that his or her exposure for costs is limited to an award on a partial indemnity basis, counsel ought not to be concerned that the normal elements of costs will be inflated by a private arrangement made between the other side and his or her counsel. And importantly, the Supreme Court goes on to find in the very next paragraph, this logic applies to situations of substantial indemnity as well. It's not restricted to partial indemnity. In any of these situations, counsel ought not to be concerned that the normal elements of costs, like Rule 57 costs, will be inflated by a private arrangement made between the other side and his or her counsel. And I have one other case that picks up on Walker and Ritchie and further explains that. And that's the Marcochia versus Gill case, 2007. This case really deals with this overlap that I was describing before, where there's Rule 57 costs, which is sometimes called party and party costs. And I'm not saying party and party scale, right? You understand, versus solicitor client. And in this case, the question was, this was a motor vehicle accident. One of the defendants was the Ford Motor Company and, or Ford Credit Company. And Ford was liable to pay the plaintiff's damages. Ford sought the ability to make submissions in the solicitor client assessment of costs. And the court said at paragraph 18, the issue is whether Ford was entitled to standing to participate and to make submissions respecting whether the court should approve a contingency agreement. And the court said, in my view, Ford's obligation to pay costs is entirely different from any obligation of the plaintiff to pay fees and disbursements to his own lawyer. Ford seeks to entwine the two obligations together, but the fact that some of the latter may ultimately be funded by money paid by Ford to satisfy the judgment is not sufficient to persuade this court that Ford should be considered a necessary or proper party entitled to make submissions at any hearing into fees and disbursement issues between the plaintiff and his counsel. So this is the proposition I was noting. Canada has no standing to address this issue of whether 100 million is fair and reasonable. The court goes on in paragraph 26 to make it clear, in order that there may be no misunderstanding about my views, I decline to read into any provision of the Solicitors Act an entitlement on the part of Ford to have standing on any hearing to establish the validity or to resolve a conflict between the parties to a contingency agreement. And I submit that the same logic applies with a risk premium or counsel fee. So this is for the point that this is an issue between counsel and their client. In this case, the Marcochia case, what ended up happening is it went on then to a second cost decision, which was related to, well, what then are the costs awarded party and party under Rule 57? And the court, at paragraphs, this site is Marcochia versus Gill, 2007, Canley, 27583. Oh, I'm sorry. Yeah, that was the first one, the no standing. The next one I'm showing you is Canley 51528. And here's where the trial judge is now actually looking at, okay, aside from what's happened in the solicitor client assessment, let's look at what costs are owed under the Rule 57 party and party assessment. And the court says at paragraph 62, having considered the factors listed in Rule 57 and having set aside factors not listed, the exercise is complete. It is not appropriate, in my view, to then add on a cost premium driven by a reconsideration of factors enumerated within Rule 57. And here the court cites Walker, the Walker versus Ritchie Supreme Court decision. Compensating for these factors again through the addition of a risk premium arguably constitutes a double count in the cost award against the unsuccessful defendant. In my view, the logic applies equally where, as is here the case, the plaintiff seeks any premium, not only a risk premium, in addition to the costs fixed and awarded against the unsuccessful defendant. And this decision was appealed to the Court of Appeal. And the Court of Appeal at 2009 ONCA 317, paragraph 50 addresses this. What ended up happening is that the lower court trial judge then said, having made the decision that you don't get a risk premium on top of your Rule 57 costs, the judge then went and found that the Rule 57 cost should be $600,000, when in fact the evidence before him was the costs were less than that. They were $559,000. And so the Court of Appeal here is stating, in our view, the $600,000 substantial indemnity costs cannot stand. The trial judge properly concluded that following Walker and Ritchie, it was inappropriate to include in a cost award the risk premium being charged by the respondent's solicitors. By awarding the respondent more than what his solicitors had calculated to be the appropriate substantial indemnity amount, the trial judge was doing indirectly what he had concluded should not be done. So what the court is saying here now is the lower court was right in saying you don't add the risk premium on top of the party and party assessment of costs. And this trial judge made an error in providing substantial indemnity costs that were actually higher than what was claimed, because that was in effect doing what they're not supposed to do. So all of this to say, Justice Hennessy, that this court should find that Canada's commitment to pay $20 million in costs on top of the over $5 million that was also paid as part of the engagement and negotiation process. This additional $20 million in costs that Canada has committed to pay.
And just remind me, it's for costs incurred after January 27th.
No, only up to January
Up to
27th.
January 27th.
We're talking about entire stage 3 trial and the negotiation and engagement session. It covers everything. Now, of course, stage 1's already being paid, right? So we're just talking the stage 3 trial, the engagement negotiation sessions, all the way up to the 27th of January. Those costs have been dealt with by Canada's determination to pay $20 million in costs. When coupled with Ontario's, it's $40 million in costs. That amount is so generous, Justice Hennessy. It is so generous that it well more than covers every claim for cost that every First Nation has had, including costs of their firekeepers and honoraria for their chiefs and council, audit fees, websites, community meetings, those things that we saw at tabs 59 and 60.
But I may be getting confused, but that's not what you say is covered in the 20 million.
Oh, absolutely. The 20 million is well in excess of what's needed to cover all of those costs. So Canada very liberally determined, without any information whatsoever from the First Nations, that it would pay $20 million in costs on top of the 5 or so it had already paid. Ontario made the same decision and said, we'll also
I
pay.
thought the 5 was for the fire keepers and the honorarium
No, the 5 was,
was different.
it's all goes into the mix. It's whatever the First Nations say they need.
Okay.
So Canada says, we don't have any information from the First Nations as to how much they actually spent. We don't know anything about their disbursements. How much did Stiglitz and Hutchings charge? We have absolutely no idea. So what are we going to do? Well, in exercising our discretion, we're going to pick a figure that we believe is liberal, honorable and liberal for costs. And Canada determines to pay $20 million in costs. Ontario says, well, we'll kick in $20 million as well. So there are $40 million of costs. Then we get information from the First Nations. As it turns out, their costs are only $13 million. All of the costs, including firekeepers, community meetings, honoraria for chiefs and council, all of those costs add up to $13 million. Well, Canada and Ontario have just committed to pay $40 million. So what happens to the other 20?
All but White Sand,
No, including White Sand Red Rock, including the cost that White Sand Red Rock set out in their letter at tab 60 that we went through earlier.
thank you.
No, sorry, it was tab 59, tab 59.
Thank you.
So the 13 million includes every cost that every First Nation has asked the Crown to pay. The Crown has not conducted any assessment about, is this an assessable cost? Isn't it interesting that some First Nations council charged a whole lot more than other First Nations council? Canada didn't consider any of that. They just said, take it at face value. We've committed to pay $20 million. There's a whole pot of $40 million. As it turns out, the cost claim, no questions asked, amount to 13 million. So what happens to the extra 13 and change? So what happens to the extra $26 million? What happens to this extra $26 million that Canada and Ontario have committed to pay? Well, it can go towards Mr. Schachter's $100 million council fee. And I submit that that's a generous approach. The Crown has taken a generous approach. The Crown is not required to pay any of the $100 million council fee, but the Crown has already determined and committed to pay what amounts to about $26 million, which will defray. It has the effect of defraying the council fee. And it's now up to White Sand and Red Rock to use the Solicitors Act process to either make an agreement with their council that, look, we've been compensated $26 million of that has been defrayed by the Crown. Won't you please waive some of the rest of the 74 million? Mr. Schachter may say, no, that's part of our contract. I'm not going to waive it. Well, then let's go to a solicitor-client assessment, and White Sand can then argue, knowing that it will be on the hook and it can make its best submissions about whether that $100 million is fair and reasonable. And the court may decide it's not fair and reasonable. White Sand, Red Rock, you don't have to pay anymore. Mr. Schachter's already you've already been fully reimbursed for your costs from Canada and Ontario. And Mr. Schachter's also received 26 million of his $100 million council fee. So that court on assessment may determine either that White Sand Red Rock does need to honor its contract and pay more, or may determine that it doesn't. That's outside of Canada's responsibility or even standing.
And when Canada and Ontario made their determination on costs, they were aware of the costs that had gone to Huron Council.
Yes.
And they were aware of that either because they read the Sudbury Star, as I did, or because they had read the reports from the decisions at the Ontario Superior Court and Divisional Court.
Yes.
And Canada says that the Crowns were concerned that there should be some, that they would be concerned if there was a significant difference between the amounts they paid the two sets of plaintiffs. And did Canada have the same view or concern about costs?
The difference is this, Justice Hennessy, the settlement with the Hurons was all inclusive. It was entirely between the Huron plaintiffs and their own counsel to determine what the Hurons would pay for costs. That was the $10 billion settlement was inclusive of costs. The Crown had nothing to do with and nothing to say about what the Hurons were paying their counsel and what those agreements were. In this situation, the Crown's offer or determination to pay $3.6 billion is not inclusive of costs. Costs are being paid on top of that. So here now the Crown does have some say as to what costs would be appropriate. And here's when the Crown very generously determined a combined total of $40 million. And it turned out to be very generous because it very well more than compensated for all of the costs claimed by the First Nations other than the $100 million council fee. But again, Canada had nothing to do with and no knowledge of the particular contingency arrangement between the Hurons and their council. And of course, if Canada did have anything to say about it, you certainly can't assume that Canada would have agreed to the 5% contingency fee. You can't make any conclusion about what Canada's position would have been on costs for the Hurons. That was a matter entirely between the Hurons and their council. The last point I'll say is, Justice Hennessy, in this hearing, my friend is asking that you have yet another hearing, a part two, a phase B, a stage B, and deal with the costs then. And my submission, Justice Hennessy, is absolutely we need to deal with costs of this hearing from January 27th to the end of this hearing. We need to deal with those costs. That can usually be done in writing. But you do not need to have a whole other hearing to hear the costs about whether the $100 million fee is fair and reasonable, because that isn't an issue for your determination, Justice Hennessy. It's an issue as between White Sand Red Rock and their council, and can and should be dealt with in a Solicitor Act assessment. And I think it's probably now time for a break. If you will permit me to make a couple comments on orders when we get back. I just really don't want to stretch people's patience.
Thank you. This is a question for Ontario. How long a lunch break should we take?
A short one, Your Honour. I'm keen to get started, so it depends on other people and the court's preference.
I'm just conscious of how long it takes people to get some food. And what can you do? What can you do? An hour? 2:15? Okay, let's do that. Thank you. 2:15.
This court is stood down until 2:15.